I'd like to thank everybody for your patience. Welcome to the premier program in Helios Data's monthly webinar series on the opportunities, challenges, and risks of data sharing. I'm Steve Troyer. I lead marketing and business development here. Most companies do an excellent job of protecting their data at rest or in transit, but when the goal becomes generating and sharing insights with business partners, protection methods for data in use are typically less advanced and effective. In our program today, we'll focus on risk that's common to most data sharing relationships today. Everyone recalls the Facebook Cambridge Analytica scandal where data was shared with unauthorized parties, and the aftermath included a $5 billion settlement for Facebook, the implosion of Cambridge Analytica, and a big hit to Facebook's reputation and value. That really put a damper on data sharing for some time. Today, I'm joined by my colleagues, David Blaszkowsky and Andy Hepburn. David leads strategy and regulatory affairs for Helios Data. I'll ask him to introduce today's speaker and program. Over to you, David.
Great, thank you, Steve. And welcome and thanks to everyone out there for joining us for this session on Minding the Gap, where we're going to explore the dangers for personal data sharing and for data providers and their partners way out beyond the traditional legal contract. We'll also talk about how new technologies like digital contracts and confidential compute enclaves may play a role in eliminating the gaps in making data sharing safe and productive in a world that's being made increasingly dangerous by new laws as well as by bad actors. I know that in most of my career, both industry and in government, it's always been about making personal and proprietary data good enough, but also safe enough to use. And the thing is that both safe enough and good enough get harder and harder as the rules tighten, but also as analytical requirements of users become more creative and more rigorous. How do we close the most challenging of the gaps, which is around usage, knowing what's actually happening with the data? So to help us with that, today's conversation is with Andy Hepburn. Andy's our new strategic market director for the advertising sector. Andy's also an attorney. Who better to help us understand the gap out at the edge of and beyond the contract itself. So welcome aboard to Helios Data, Andy.
Thank you, David.
Who comes to us with his law firm also, Neo Law. So as we get started, just tell us a bit about yourself.
So yeah, I've been practicing law for over 30 years, primarily in technology companies and data related companies. So I've spent a long time focused on these issues around data governance, data compliance, managing risk around data sharing, and so forth. And especially in the last 9 years, I've been involved in the advertising technology industry. My last company, I was general counsel at a company called Seismic, which was a ad tech platform, which means they serve ads to your phones and your websites and so forth. And that company is now owned by Amazon. So I've gone out on my own and am helping companies with their privacy compliance and their data governance activities.
Well, great. We're glad to have you aboard, and we're glad to have you here today to talk to us about starting really with so what is this gap and where is it? So look, as you know, written contracts have been with us at least since the Egyptians and the Mesopotamians, and whether it's clay tablets written on paper or as ASCII characters in Microsoft Word, they seem to have endured pretty well as far as technologies go. We have master contracts and exhibits and orders and data processing and agreements and all. So, what is a contract, and what are the key characteristics that we need to keep in mind, broadly speaking?
Yeah. So I think what I want to do here is just focus a little bit on, just for context, is what is a contract, and then why are they being challenged in the present day with the the data sharing activities that are going on. So the first thing is, a contract is a legally enforceable agreement between two or more parties. And so when I say agreement, what that normally means is promises. So David, I might promise to cut your grass if you'll promise to pay me $25. And so that's a contract if we agree on it. The question is it legal? There's another question, is whether it's legally enforceable. So if I change that scenario and say, I'm going to sell you some heroin if you pay me $25, That's not a contract because it's not legally enforceable, because no court is going to enforce your obligation to pay me $25 for heroin. So that's an important little distinction there. But the other thing that contracts do is if a party doesn't fulfill their promises as agreed in the contract, they create remedies. So I can sue you if you don't pay me the $25 for cutting the grass. Or, you know, as it relates to this topic today around data sharing and digital advertising, you know, there's a common term in these data sharing agreements between a website owner and an advertiser who wants to place an ad on that website. And it says, I'm going to give you some data about the visitors that come to my website, but you can only do certain things with it, like use it to serve a good ad for that audience. You can't take it and share it with other third parties or create your own, you know, advertising technology solutions with it. You can only use it to buy an ad and place it on my website. And so that's where, so the question here is, well, if the buyer, the advertiser, uses the data that allows them to find a good visitor to that website for other purposes, what can the publisher, that website owner, do about it? So that's an important, important issue. It's where people are really challenged today.
Well, you know, and when you think back to those Mesopotamians and Egyptians and others didn't have, you know, programmatic advertising to worry about. They weren't moving data around. They didn't carry out digital marketing. All of this, you know, all of what we're dealing with feels kind of new and different and may open up challenges for these documents. What are some of the places? I mean, as you look at it both as a lawyer and as an industry innovator and leader, you know, what is the gap that's emerged in terms of what a contract can do and maybe what it's not able to do today, that gap?
Yeah. So the gap is primarily around the remedies that the contract gives to the parties if the other side breaches the contract. And so the traditional remedy that a contract provides to a party is that if the other side breaches, shares the data without authorization, for example, the remedies, there may be really two. One is, you know, we have ongoing audit rights. So we have, the contract says, you know, the publisher, in the example we're using, the website owner, can audit the data recipient's use of the data maybe once a year. Then the other is, if they know that the data recipient has made unauthorized use of the data, they can bring a lawsuit. Well, neither of those remedies does anything about stopping unauthorized data use or data sharing. And that's the gap. The gap is that in the modern world where data is being shared real time in significant volumes, with potentially, you know, tens of thousands of consumers' data being shipped around the internet in real time and being made use of, the remedy of hiring a lawyer and doing a bunch of you know, investigatory work and going to the courts, it just doesn't solve the problem of stopping the data sharing, the problematic data sharing, and you know, remedying the problem sort of in real time, just like the data sharing is going on in real time.
Well, so that's interesting. I mean, that raises a kind of risk that doesn't show up a lot when you run as a Google search or talk to folks, right? This thing called usage risk, right? And usage risk, you know, I guess it's always been there, or at least it's been there as long as people have been sharing data. Why are we only starting to talk about it now as maybe a discrete form of risk that needs to be addressed, you know, by technology or others?
Yeah, and I mean, data usage issues have been around for forever. I mean, you know, there's an example of Shakespeare had a play called our Cardenio, and it's gone. No one knows where it is. No one can find the manuscript. There's been ongoing examples throughout history of people making, you know, stealing data and making use of it for their own good. We have, you know, there's a great big example with China stealing intellectual property of U.S. companies. But the problem is that in the modern world, really since the internet came on the scene, It's just the pace and the proliferation of data in general makes it a lot harder to govern that. So before, you would have a non-disclosure agreement. And if you noticed that your data was being, disclosed without authorization, you'd go file a lawsuit or get an injunction. But these days, by the time you start using those kinds of remedies, the data is long gone. It's been proliferated throughout the internet. And this is the problem here is that we're talking about people's personal information that can be used for really bad purposes, like hacking, like data theft, that kind of thing. My son has, been dealing with a data theft problem for the last 6 months, and it's really painful for people. So this has led to the proliferation of privacy laws in the modern day that are designed to help companies control that data, tell them what needs to be done, protect consumers, and that sort of thing. So the stakes have just gone way up in the last 10, 15 years.
So what you're saying is really, if you're not covering that usage risk, all the great protections in the world won't protect you and your customers or other stakeholders from that risk. I mean, it's just too late, right?
I mean, so the written contract is still important, right? I mean, you still want those remedies of being able to go to court and get some money paid by the other side if they've breached the contract. But that doesn't help the consumer you collected data from the consumer, your partner shared it without authorization. Now you've got a data breach on your hands, and it doesn't help you protect the consumer. Right. What could help you protect the consumer is a real-time method for detecting the data breach and stopping it when you see it. And that's where digital contracts can come in and I think provide some significantly improved solutions.
Right. And of course, for companies with data that's valuable and productive, and assuming consent and other aspects have been taken care of, if the data is lost, that's value to them and to their shareholders and others that's lost as well, right? I mean, it's not just
and not to mention that, the European data law, it's called GDPR, the General Data Protection Regulation, and it's in place in the UK and all over Europe. It not only, creates issues around liability if you harm a consumer by unauthorized exposure of their data, but it also has fines up to 20 million euros, or if greater, 4% of your annual profits, or your annual revenue. So, I mean, there's significant risk and liability around not getting this stuff right for companies that regularly deal in personal information of consumers.
So Andy, from a very practical perspective, I mean, how are companies scrambling to address this source of risk, or at least what are you seeing, both as a lawyer and as an industry leader?
Well, so the first point is they are scrambling. It's, there's not only, I mentioned the European law, but there's a new law in California, a new law in Virginia, a new law in Colorado, probably 6 other state legislatures that have on their dockets new privacy laws. And so there's a new one in Brazil, a new one in Japan, and a new one in Australia. So there's really a mushrooming kind of proliferation of privacy laws all over the globe. So you might imagine that companies are scrambling to comply, and it's a significant challenge. And it involves understanding what data you have in your possession, how you're using it, processing it, manipulating it, and even as important or more important, with whom you're sharing that data. And so the laws generally require you to know all that information, document it, and be able to share it and control it over time. And so it's a significant challenge, and companies are spending literally billions of dollars around the globe trying to get their hands around this.
Right, and to do this, I mean, technologies have really been the traditional go-tos for protecting data that's being used, right? I mean, obfuscation techniques like anonymization and data masking, encryption technologies like differential privacy and homomorphic encryption. Yeah. I mean, they've been a crutch, but I mean, to take even just one of these, one that's very popular, why is like anonymization problematic?
Well, one is it's hard to do permanently. And there was there's a Canadian privacy law, And as they were looking at this issue of anonymization or the similar concept of de-identification, they found that it's with one extra data point, it's not that hard for data scientists or even hackers who are kind of data scientists to actually re-identify the data to an individual. So I guess that's the main point, is it's hard, and it also slows down the use of data and all sorts of other challenges.
Right, and even changing and degrading the data, and then encryption techniques, like the ones mentioned, can be incredibly expensive computationally, and take a long time and require special staff and experience. It's, there's really been a rush to try and come up with ways to address this, and not so successful so far. But you mentioned a few moments ago digital contracts is perhaps an answer to that. And these are also known as smart contracts. They're all code representations of a legal agreement. Can you talk a bit more about what they are, how they can address these operational requirements and challenges you described before?
Yeah, so I think the main thing is, just to use like a very concrete example, is if you have a publisher, a website owner, and an advertiser, the contract around sharing the data of visitors to that website with the advertiser, so they can decide if it's a good site for them to serve an ad on. That's the purpose of it. It'll have a restriction in it that says, don't share this data with third parties. Well, the problem is it's very hard to know if that restriction is being followed by the advertisers, especially in the digital advertising environment. It's an auction environment. So you're not talking about one-to-one, you're talking about one website publisher to many. And so what you need to be able to do, so the words in the contract say, don't do it. But that's a big problem. This is not a hypothetical. It's a real world problem for digital publishers. And so what they need to be able to do is monitor with whom they're sharing the data, and if it's being sent out further beyond that company's use, or if they're using a third party to do their stuff. So you need a tool that represents that don't do this in a way that can be audited and measured in real time. And so you write that rule into a digital contract, and you can help the audience understand more about how that's done. But the digital contract is essentially a software representation of a concrete rule in a contract that can be monitored and measured and essentially responded to if a problem occurs in a real-time fashion, and also very securely.
So, I mean, does it matter what kind of data is addressed by a digital contract? Can you say something about the kinds of terms that could perhaps be encoded and used in a contract like this? What is it able to do? Yeah,
so like an example where it won't work is almost every contract between businesses has a clause that says everybody will comply with all applicable laws. Well, that's a really hard thing to write into software code. But what if it says, the example I've been using, don't share this data with any third parties or use it for any purposes other than X, Y, and Z? Well, that's a much more concrete rule. And so it's that kind of thing. And, it gets at the crux of the do's and don'ts, so that's a very concrete thing that can be expressed in a software environment and then managed for compliance over time.
Right, so things that are measurable, addressable, can be judged. That's actually pretty exciting. I mean, many of those things are hinted at in legal contracts.
Right.
This is the place where they can be characterized and then surveilled and monitored and addressed. So, so it sounds like this is a tool that can be used to close that gap, right? And that this would work even better if you're able to use it as a means of governing, let's say, a secure computing location, or what we call a secure enclave. Can you talk a bit about that as a possibility?
Yeah, and I think that's where, from what I know, that's where the Helios data solutions can come in and be helpful. Is they create this secure enclave, a secure environment where data can be inputted and software processes, algorithms, application programming interfaces can be can be run on that data, and what goes out to the recipients, in the case we've been talking about, the advertiser, might not be the actual original data, but a result from that processing. And so you're able to keep the data in a secure environment, and not, in some cases, maybe not even have to share it at all. And if you don't share it at all, you've really reduced your legal risk, is the key point about, I think, what can be done with these sorts of offerings.
So what we do in the Helios data sharing platform, as you're describing, right? Digital contracts govern the processing in a secure enclave, and data providers on the one hand and their partners with algorithms are able to construct through screens in our platform a contract that includes information drawn from the legal contract, like purpose and duration and parties and policies, plus things that you usually don't see in a legal contract itself that are critical to data safety enforcement, like the computer address of the data, the exact computer fingerprint of the approved one and only algorithm, and the characteristics of the processing environment, among other items that could be included. I mean, and then with any anomalies, as they're discovered through the processing, that's one of the unique aspects of this, 24/7 and in real time. Yeah. That any anomalies in these during processing, the processing can be terminated instantly. So that's introducing enforceability, which isn't traditionally available in a paper contract. But it's based on the contract, and it extends. It actually specifies and operationalizes the legal contracts, such as the gap is closed. Is that sounding right? Sort of like the legal contract and the digital contract as partners integrated for the safety of data processing.
Exactly. And the thing that's most exciting for me about this is right now my contract says if I want a remedy, I have to do an audit, or I have to go to court and file a lawsuit. But if I write into my contract, we're going to use a digital contract solution for these discrete operational activities, I probably never have to do that at all. And that's good for both parties.
It's almost like we're talking about something different from the usual risk mitigation and allocation that you find in standard contracts. We're talking about eliminating the opportunity for a risk to even come into existence.
Right.
And that's a cool and different thing that's possible with these unique technologies. We've kind of hit the time that we wanted to hit, to take at least a question or two and still keep this short. Hey, Steve, if you're out there, can you tell us if there are any questions that we can address?
One moment, please. I think you talked about some different techniques there. Can you talk a little bit about the relative costs and maybe compare those, David or Andy?
Yeah. So if we talk about the costs of being able to use, let's say, a legal contract versus these computational techniques like encryption or anonymization. I mean, contract costs, which you'll keep anyway, right? I mean, the lawyer doesn't disappear from this, right, Andy? I know this isn't a job protection, kind of thing. The lawyer still has a role to play, but ...
Right. And I mean, the thing is when I negotiate these contracts all day long, every day. And one of the main things people argue about is how much liability do I have to take on if I mess up and share the data inappropriately? So this is the company that's receiving the data and doing something with it from the other party. And these controllers, the company sharing the data, they'll normally ask, I've seen as high as $30 million of liability. That's a lot of liability. So if you can prevent that problematic data sharing, because most companies there are bad actors, and those are important cases, but most companies, they just mess up. They just make a mistake. They're not bad actors. They're just maybe negligent. So if you can help them, your partner, by not having either stopping the bad data sharing from happening when you notice an anomaly, or arresting the problem and preventing the problem in the first place, you've not just helped yourself as the company, as the owner of that data, but you've helped your partner avoid a lot of potential liability that you'd be suing them for. So, I mean, hopefully it cuts down in litigation in the courts.
And so then when we talk about when we talk about secure data sharing, the Helios data model of a contract governed secure enclave, we're really talking about eliminating the opportunity, the possibility that there'll be those kinds of costs down the road. So not only are we talking about a solution that is itself low cost and low, unlike encryption techniques, doesn't require very powerful computers and tremendous lead time and all that. We're talking about a way of being able to carry out work and keeping it and avoiding these kinds of onerous costs in the future.
Yeah, exactly. And it's interesting. It looks like we got a question from the guests, and this question is actually on that point. It's about the privacy shield that was recently invalidated by the European Court of Justice, which is essentially the Supreme Court of Europe. And it involves, this is a separate topic. We're not going to be able to answer the question, but one of the implications of that decision is that it becomes questionable whether a European company taking Europeans' personal information and sharing it with their data processing partners in the US, it can be done lawfully because of the European data protection law. And one of the things they say, so there are methods to do it lawfully, but the requirement is that you make sure that US surveillance capabilities don't unusually affect the data sharing. And so the question is, could a digital contract like this be used as a method to increase the protections? And the answer is absolutely yes. I mean, I think so. You know, the Helios experts will have to tell me more, but I think if you can prevent the data from being transferred to the US at all, and only the results of the processing get transferred to the US, then I think that's, you know, it's worth exploring as a complementary measure for data protection in Europe.
Well, that is a really exciting opportunity, and we could explore in a future session how the fingerprinting that our secure data sharing platform does of algorithms and results is in fact one of a unique way and a uniquely effective way of being able to ensure that there is nothing coming in piggybacking on that analytic or on the data, right, to ensure that there's no surveillance of what's actually going on. That's an exciting topic for a future session that we'll carry out. Well, with that, let's bring this to a close. I did want to just wrap up a couple points from what you said, Andy. First, that you know, the agreement that legal contracts do leave some enormous gaps that need to be filled in. Usage risk, that's a great unmet, unaddressed frontier. And that alternative technologies that are commonly used today, like obfuscation and encryption, they serve a purpose, but they can't eliminate that usage risk in particular. And thus, they're not in a position to save data from the risk of misuse, reuse, and breach. Meanwhile, the newer technology of digital or smart contracts can provide the answer, and Helios Data's integrated digital contracts and a secure enclave for data and use processing. On that, we really look forward to you know, to all of you who are participating or watching this on playback to come and talk to us, see us at Helios Data about how to close that gap and renew your sharing of data safely and productively with our secure data sharing platform. Really, it's the opportunity to use digital contracts to govern and ensure that your data is processed safely, securely, and productively. Thank you very much. Back to you, Steve.
Thank you, David. And I want to thank all of the people who've attended today. Just a quick heads up, we will be having these sessions on a monthly basis. The next one actually is going to come on the 30th of September. And we'll be doing that with Adweek. So we will make sure to get the details out to you in the next couple of days. So you can have that on your calendar, and we'll have an expanded discussion with Andy, myself, and folks from Adweek. So thank you very much, and enjoy the rest of your evening. And please come and visit us at heliosdata.com to learn more. And we can help you with your data sharing challenges. Thank you.
Thanks, everyone.
Thank you.